Good afternoon. My general proposal, which I hope I can stick to, and I'm sure I will, is facts this afternoon, and everything else tomorrow, with the intention of finishing before short adjournment. So that's the plan.
Very good. Well, if you can do that, that's splendid.
I do need to.
If we need the afternoon, we've got it. But if we can finish, then all the better.
I promise Mr. Elias I will leave him some time for a response, and hope that we can get an early afternoon as well. That's
Very good. Very good.
So may I start with some basic propositions? Because what I want to do is to dispel what we say, with greatest respect, are the wrong impressions given yesterday as to the context in which the judge reached his findings about the defendant's honesty. Once put into their proper context, they were available to him on the evidence, and I hope to spend some time to make that good. The first thing I want to say is this is not an appeal on facts. If one reads the appellant's grounds, that they're all matters of law. And there is always a danger on both sides that one tries to relitigate matters of fact. And I'm not blaming Mr. Elias for this at all, because he's suggesting that the judge has not given reasons or sufficient reasoning. And in that regard, he wants to look at some facts to show what the judge might have addressed himself to. The difficulty for that with that approach for me is that he, and I don't mean this in any sense critically of him, has picked out paragraphs from his client's witness statements, which if believed, might have provided a defence. But that's not the context in which that evidence was given. So if this was an appeal on fact, we would have all the transcripts, most of the documents, and so on and so forth. So I will do my best to stay as anchored as I can in the judgment, but there will be a few documents that I will take you to along the way. The next point I wanted to make by way of opening was that the court's comment yesterday, I think it was Lord Sir Launcelot Henderson, said that there is a challenge where you are trying to displace findings of fact or findings of dishonesty, which follow a detailed trial by an experienced judge. And whether one describes that as an uphill struggle or a high hurdle, for my purposes, makes no difference at all. But we very respectfully agree with that. But that doesn't mean to say that the judge gets a carte blanche, and that is essentially what this appeal is about on this particular topic. So that's my purpose, is to try and bring your lordships back to the context in which the judge made those findings that he made. The next point is that Mr. Elias said to you yesterday that the judge turned to dishonesty only at paragraph 359 of his judgment. As I hope you will see by the time we've finished later this afternoon, we submit that that is not a fair representation of the judgment as a whole. And when one gets into more of the detail, one then sees what is sitting behind the decisions the judge has made. I next want to introduce what looks to me as if it might be shaping up as a core issue on this aspect of the appeal. That is whether the defendants can be permitted, as it were, to invite this court to reframe the question that the judge appears to have answered in the judgment. Well, this goes back to whether he's asked himself the right question, if you remember that submission from Mr. Elias yesterday. I will be coming back to this, but obviously I'm going to do my best to vindicate the judgment as it stands, and I'm going to invite your lordships to say that no reframing is either necessary or possible when we've looked at it in its fullest context. The next point I want to make, which Mr. Elias made about our case, and I think Lord Justice Mayles made this morning about both cases, including
yes,
the defendant's case, is the question of, if you like, on the one hand, our loss of the dishonest misrepresentation claim. And on the defendant side, their losses plural in respect of the profit share agreement and the question of authority. It's important to understand that the profit share agreement and authority were the primary points deployed by the defendants at trial. There was a positive case advanced that Mutaz had the fund's authority, and that Mutaz, on behalf of the fund, Fimmel and the Floreat shareholders on the one hand, and the individual defendants on the other, had a binding profit share agreement which sat somewhere, we never understood where, but possibly one of the reasons it failed, but it sat somewhere above any of the corporate structures in place, and appeared to have the ability, as put, to intervene to capture any revenue that might be coming in at any layer of those corporate structures, even right at the top. But as we will see, the allegation was very clear that the profit share agreement had been entered into by the fund as well as the Floreat interests, as I would call them. So the importance of the profit share agreement to the trial cannot be overstated. And because that can't be overstated, its potential impact on the decisions that the judge must then have to make would also be difficult to overstate. Now, I'm not going to ask your lordships to read through all of these paragraphs with me, but I'm just going to alert you to the central significance of this in the defence. So the defence, just for your note, is in the core bundle, at core 2, tab 22, page, I'm going to pick it up in a moment at page 367. But let me just give you the paragraph numbers. I've got my some notes written out so I can read them more quickly than I'll find them. So if I read ahead of you and you want to slow me down, please say so. But I don't want to get stuck in the weeds of this. But I do want your lordships to know that it wasn't something that appeared in one paragraph. So paragraph 7. It said that IRL was the company to which, to the knowledge of the fund and Fimmel, the FCM profits due to the individual defendants pursuant to the profit share agreement were paid. Paragraph 8.1, there was an assertion made there was no diverted sum. The payment of half the termination fee to IRL represented the application agreed with Mutaz brackets on behalf of the fund, Fimmel and FCM, close brackets, of the profit share agreement to the termination fee. I do want to spend a couple of minutes introducing paragraph 17 to you, so I am going to go through this a little bit more slowly. The quotation I want to bring to your attention, first of all, is in or about July 2013, page 371. It was agreed with Mutaz and Hussam and FCM that they would share net profits 50-50 with the individual defendants as reflected by the 50-50 management and ownership of FCM. This was to be applied on an agreed basis to each loan transaction. Following the incorporation of the fund and Fimmel entering into the investment agreement and the management agreement, it was agreed between the individual defendants on their own behalves and FCM, and with Mutaz on behalf of FCM, Fimmel and the fund, that arrangement would also apply to the net profits in respect of work done by FCM on behalf of the fund and Fimmel. Lord, the importance of that then becomes clear when one looks at the schedule or the table on the next page in paragraph 17. Now, nothing I say is intended to be a sideswipe at or critical of Mr. Elias, but he did, I think, perhaps not meaning to, may have left you with the impression that what was happening in respect of the Reading fee was just simply a continuation of what had happened before. And for reasons I'm about to explain, I think that is not really open to him. I will be coming back to this a bit later, but by way of short introduction, if I may, some sums due to FCM had been distributed as set out in Table 17, but they all share a characteristic which the termination fee does not share. The characteristic they share is that they were introductory fees. Now, your lordships have been taken through the documentation of the offering memorandum, the management agreement, and the investment agreement. And I don't want to get into arguments at this stage, if I may, in respect of fiduciary duties and modifications thereto. But what we do know is that there was a modification which could broadly be said to sanction what might otherwise have been a strict breach of fiduciary duty, for example, the negotiating and receipt of introductory fees, going straight to the investment advisor. So we'll come back in due course to see what the judgment said about it, because the judgment vindicated what I'm saying now, is that the introductory fees paid under Table 17 were paid pursuant to contracts entered into by third parties and FCA, third parties who were to take loans from the fund. So that was never money due to the fund. The key difference is that, of course, the termination fee was money due to the fund. Whilst I'm on that subject, can I just leave you with a footnote where it was said yesterday, I think, by Mr. Elias, that the termination fee was could be seen as somewhat different because you had the return of principal and the return of the interest on that principal and the termination fee. But of course, the termination fee is in fact interest. It's just paid to compensate the lender on the basis that the contract has come to an end earlier than it might otherwise have done. But it is still in fact an interest payment. So, and also, when we...
Well, it's an interest payment, it's a notional interest payment on money which is no longer being loaned.
That's right.
On which the fund has the opportunity to earn interest by deploying it elsewhere. Which it intended to do, and presumably did.
Well, obviously the termination fee is designed as a compromise normally, which allows any lender to redeploy, but also gives it some future compensation in the event that it can't redeploy. That is my understanding of what, logically, what that would normally be negotiated to achieve. So your lordship's quite right, but it would sit in that area.
I mean, it's maybe a bit of a quibble. It's not strictly interest, is it? But it's a payment in lieu of interest.
In lieu of interest.
In compensation for not receiving interest.
Well, I absolutely take the point. Absolutely take the point. But we will see in due course. You will come to it, and you will, I'm sure, slot it into its respective position when you do come to it. But when we discover the idea that had been found by the defendants in order to try and swing this payment as a payment that could go straight to FCM in some fashion, you will see a reference there to conflict. And that reference, there's no conflict in relation to this termination fee. That was in respect of why the prepayment fees fell into an entirely different category. So that is what I want to say at this stage about Table 17. I probably said slightly more than I should have done by way of an introductory comment, but I will come back to it when we see it in the judgment, because it will be, I hope, at that stage fairly helpful. Then paragraph 77.4, statement is the termination fee was to be regarded as profit and therefore split 50-50 in accordance with the existing profit share agreement. Paragraph 101.1 they, I think that's referring to the defendants, regarded that such sum as might be negotiated for early repayment by way of a termination fee would be profit of the Floreat group owing to FCM to be split in accordance with the profit share agreement. So something of a muddle in that paragraph. But
sorry, I got 77 subparagraph 4. Where's?
I'm so sorry, my lord. I did say I'm probably going to make a mistake of going too quickly. 101.1 was my next one.
Sorry, the one before that was 77.4.
77.4, your lordship's quite right.
No, thank you.
Thank you. 101.1. So they regarded that such sums might be negotiated for early repayment by way of a termination fee would be profit of the Floreat group owing to FCM to be split in accordance with the profit share agreement. It reads as if it was all supposed to be going to FCM, but I don't think it intends to do that. And then paragraph 116.3, page 406, 407, the second sentence. This was a reference to the 50% share that they expected under the PSA. The reference to not 25% represents the fear of dilution of their interests pleaded above. And pausing there for a moment, my lords, that's an obvious reference to money as they would see it being siphoned off for Floreat Merchant Banking, FMB. Then there's a reference, this is all stuff in the chat. Whether it was a joke or not, I don't think is material for today. Then we go to 125.3. We get this expression. It's admitted at this stage the question of which entity would receive the termination fee had not been discussed in the Tazatabi. So IRL was put in the document as representing a holding position. I'm going to come back to the holding position in due course when we look at it in more detail. On the basis that 50% would subsequently be paid over to the Floreat group offshore, the cancellation notice was seen by the individual defendants as a way to apply pressure to RFC. The document which would regulate the payment was to be the deed of release. The reference to Mr. Lebeau is misleading, and I don't think we need to worry too much about that. But the reference to the holding position was mentioned in court yesterday, and that is where it appeared in the defence. Next one is 129.8. We get that one on page 113. The intention was that pending any contrary agreement on the point, once it had been raised with the Tazatabi, the fee would be split 50-50 offshore in accordance with the profit share agreement. Again, paragraph 137. Short quote from this one. At the meeting, it was agreed that the termination fee would be split 50-50 in accordance with the PSA. 138, the monies were transferred to FCM Cayman and IRL pursuant to an agreement with the fund and FIML on the basis of informed consent, which itself represented the implementation of the profit share agreement. So absolutely embedded in what they say was the fundamental basis of their discussions with Tazatabi. Paragraph 160, I think is the last one I'm going to take you to. And the quote is, this payment was made pursuant to an agreement with the individual defendants and the termination be shared under the profit share agreement.
Sorry, which paragraph number?
I'm sorry, my lord, 160.
160.
160. So I'm not suggesting that that is a completely comprehensive list of references, but it's enough to make the point that it was central to the defence, that it was central to the reliance on Table 17, and it was central to there not being an ad hoc agreement with Tazatabi, but an agreement with the Tazatabi, which in fact represented the implementation of the profit share agreement. So with that introduction, can I now please take you to the judgment? Because there were two profit share agreements, just to complicate issues, two pleaded, none found. The first was the 2013 agreement, And we can pick that up, please, in para 57. I'm sorry, ignore that, cross that one out, 58. So this is the judge's introduction. The defendant's case was that there was an agreement they described as the profit share agreement formed in 2013. Paragraph 59, the defence described it in paragraph 17. Your Lordship has seen that quote and the table that followed it. We then look at paragraph 60. At trial, Mr. Itaby gave his evidence, and I won't slow you down by reading it out. I'll just pause for 10 seconds to let you read it. Paragraph 61, I accept Mr. Itaby's evidence. It's consistent with what the parties did at the time in forming FCM London. A number of documents from later dates were put in on behalf of the defendants to Mr. Itaby to challenge his evidence on this. His evidence withstood the challenge. Lord, may I make a footnote point at this stage? When one is, the court's then going to be invited to go off and make a judgment on this judgment, as it were, an assessment of the judgment. What is a striking feature of it is that everybody came off well and badly in almost equal measure. That is to say, there were findings of the court favourable to Mr. Itaby on fact, and findings of the court favourable to the individual defendants on fact, and as we know, findings in respect of all four of them going the other way. And one of the points I would like to leave you with is that is not the hallmark of somebody who has not addressed the evidence with the sort of evaluative detail that this court would expect. It's the sort of approach which gives the confidence that what has happened is that someone has considered 11 days of evidence, 10 days of evidence, however many it was, and has evaluated the transcripts, impressions of the witnesses at the time, notes made during the trial, all the various mysterious ways that trial judges will go about their tasks, which I'm not going to speculate on. But I would respectfully submit, I'm sorry it's a long footnote, but I respectfully submit that's actually a confidence-building point. If we then go to paragraph 62, we then see the judge saying what the deal was. In other words, what was agreed and done was to establish FCM London as a company in which the ownership was equally shared and from which dividends would be equally shared. Where FCM London achieved profit, that benefit would be enjoyed equally by the two shareholding groups, but only in the way that shareholders benefit from the success of a company in which they have shares. Profit would be after costs, including salaries, and as you heard, they were not insubstantial. Profit would be after costs, including salaries paid by FCM to Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh. That is where the parties ended up. However, they may have discussed it in initial negotiations, and however the position may be confused by subsequent performance, differing from what was agreed. So that's the judge acknowledging that there may have been other discussions, and paragraph 17 may say other things in respect of certain types of payments, nothing more than that. Paragraph 63, to the extent that the defence suggests more than this, I do not accept it. The evidence from the defendants was imprecise. Then we have an example from Mr. Diallo, where I don't need to pick on him. And paragraph 64, in closing, the fund seeks a finding that there was no 2013 profit share agreement. I'm able to make that finding. Very clear how he's gone about that task. If we can go then to 2000 to page 90, and we'll pick up references to the 2015 profit share agreement.
Sorry, what page did you say?
Sorry, paragraph 90.
Paragraph.
If I said page, I do apologise.
Yep, that's fine.
So, here we go. The defendant's case that there was a profit share agreement continued. So this is following the incorporation of the fund and FIML and the entering into of the IA and the IMA. It was agreed that the individual defendants on their own behalves and FCM London and with Mr. Tazatabi on behalf of FCM Cayman Fimmel again and the fund, that arrangement would also apply to the net profits in respect of work done by FCM London on behalf of the fund and Fimmel. Now, what's important about that potentially is that this cannot relate to, on the face of it, the sharing a la Table 17 of separately negotiated introduction fees. This is work done on behalf of the fund and Fimmel. That was the allegation, and that the fund had signed up to that. So paragraph 91, it was further alleged that agreement was performed by the parties satisfactorily to summer 17, that 50-50 agreement being a standing agreement reached and or continued under clause 4.7 of the investment advisory agreement pleaded above. Paragraph 92, I do not accept that the alleged profit share agreement was a standing agreement reached or continued under 4.7. Just pause for a second as your leaderships finish that paragraph. Which will bring us to 93. The defendants provided no evidence that persuaded me that following the incorporation of the fund, etc., and he quotes part of what we've just seen above, there was an additional agreement in the form of the alleged profit share agreement 2015. No such additional agreement was documented. I've already made clear my finding that there was no background of the 2013 profit share agreement. So just to finish this off, over the page, please. Paragraph 95. However, the most important aspect of the alleged profit share agreement was not whether division was 50-50, but what was to be divided. 96. The defence refers to the arrangement applying to net profits. In its defence, when dealing with the alleged profit share, a table was provided by the defendants for the purposes of the proceedings. Your Lordship, I hope, take it from me, that is Table 17 attached to Para 17. It is there set out that net profits split agreed by the parties of the activities undertaken by FCM prior to the current dispute, all on the basis of the agreed 50-50 basis. Para 97, the table shows 16 items of revenue with trade dates across the period of 18th February 15 to the 21st of December 18. Some are modestly reduced before being restated as dividends. Leaving aside the item concerned with these proceedings, the remainder are principally upfront fees or quarterly fees attributed to a new fund, Fan 1, discussed further below. None appears comparable with the Reading termination fee, which, as will be seen below, in my judgment, a contractual termination fee payable to the fund on redemption or exit of the note facility made available by the fund. And that fee is one of those shown without reduction before being restated as dividends. So this develops the point I made earlier, and that is how the judge dealt with it, and he dealt with it, in our respectful submission, robustly. Paragraph 99, and I should say to Mr. Elias, if he thinks I'm missing anything out that he thinks is relevant, he's very happy for him to interrupt me. Paragraph 99. There was evidence at trial that Mr. Diallo was only later in 2017 to have the, quote, idea, unquote, of applying any profit share agreement to the Reading termination fee, and even then that idea was not agreed. There was then some cross-examination about that, looking at the rest of that paragraph. Now, what I would like to do, and unless I'm imposing unreasonably on your lordships, is invite you, please, to read through paragraphs 100. And I'm going to ask you to do it now, unless that distresses anybody too much, because it will be much quicker than me reading it. But I would like your lordships to see the context of the cross-examination that then followed on the 17 point.
Yes, right.
Lord, I'm very grateful. Can I go to paragraph 103 then with you, unless you've all got to the end of that section already? The subject was addressed again at a different stage. I asked Mr. Diallo, what do you mean by the expression, "I've found an idea"? Answer, it's basically me anticipating this chat with Mataz, where he's 100% going to try and renege and dilute our shares. This has been the overriding theme. You can see it when you use the words standing firm, standing your ground, dilution, so on and so forth. And then in a later answer, he said, I knew these profits 100%. These were profits 100%. We all agree they were profits. But in this profit share, especially with the fund, because contractually this was due to the fund, you have Mataz, who sits on the investment advisor, manager and fund, so he's got the overriding control. He can just simply, if he wishes to, renege on the profit share. And this is just me reminding myself. So paragraph 104, there is then a comprehensive rejection, again, of the 2015 profit share agreement. Now, importantly, that rejection, none of the rejections in relation to the PSA are challenged.
The judge does go on to say in 104 that FCM London is entitled to payment from FIML for what it's done. But he never, well, let me ask, does he follow that up at any point to explain what the payment is to which they are entitled, or make any findings about that?
No, he does not. The Lordship is quite right. And the entitlement is, as I think you identified with Mr. Elias yesterday, if you like, almost in part an agreement to agree on a case-by-case basis with a possible route to expert determination. I think all that is a reference to entitlement under the investment agreement without actually specifying what that would have resulted in. But what you can see, and I'm going to, we'll come on to this in due course, but you can see the judge was entirely satisfied that the fund structure was that income due to the fund would go to the fund. There was a NAV requirement, net asset value, quarterly net asset value requirement. We also know about the cash reserves requirement, and I'll be coming back to that in due course. And then the fund would make a decision whether it distributed, and if so, what. That distribution would necessarily be to FIML. FIML then had, if you remember Mr. Elias's plan, or schema, then it had sitting below it FMB, the placement agent, and FCM London.
When you said distribution, did you mean distribution when you said distribution to FIML?
That I think is what Mr. Elias is calling the excess. So in other words, at some stage the fund would do its quarterly NAV calculation. It would look at its cash reserves. It would, if I may say so respectfully, agreeing with my Lord Launcelot Henderson, it would look at the lifetime of the fund requirements, not just on a case-by-case basis, because it would have so to do. And if it felt confident enough to do so, using investor language, it would then pay out a payment which was theoretically therefore excess the coupon, and that payment would necessarily go to it under the agreement. That was
all right. So it's not a distribution.
Sorry,
I'm sorry.
Sorry,
because FIML is also the shareholder, isn't it?
Yeah, it was for a company lawyer, my Lord, it was an entirely inappropriate piece of vocabulary for me, and I do apologise.
Sorry. Yep.
I didn't mean it distribution in the shareholder sense. I'm so sorry if that's who you.
Sorry.
That was my fault. So, so that was the fund structure. There's no doubt that was the fund structure, and there's no doubt that the individual defendants knew that that was the fund structure. Can I have a little footnote on fund structure? It was said yesterday that this fund structure was unusual, and something's been made of that on the basis that there are a number of pies with Metaxatape's fingers in them. But But there's no evidence that it was unusual. The judge made no finding about that. There was no expert evidence, which there would have to be. There would have to be some sort of market survey if someone was going to give that evidence. And you know, Leonard Friend might think it's unusual, and his clients might think it's unusual, but there's nothing before your lordships upon which that submission can be sustained.
Well, there was something in one of the witness statements, I forget which, where the witness said this was unusual because it placed pretty much all the upside, or retained pretty much all the upside for the benefit of Fimmel, whereas you would expect investors in the fund who are anyway looking at an above market rate of return to have wanted to have a share in equity as well.
It was certainly said by one of the defendants that it was unusual.
One of the defendants.
Yes. But the point I'm making is that there was nothing before the trial judge on which he could make a market finding in respect of that. And the reason everyone would have to be, if I especially say so, cautious about it, is that if there is a 5% coupon, then one would have to investigate where that sat in the marketplace to see whether that was then a satisfactory return for investors or a good return for investors. So all I'm saying is it would involve an investigation into that kind of investment fund, which the court was not provided with. The next footnote I want to say is that it was said yesterday that FMB was something of an afterthought. Now, the implication behind that is that it was put in subsequently in order to allow the 50-50 profit share, which doesn't exist, in some sense to be diluted. In other words, to have some way of saying that the Mataz could siphon off money for the Floreat interests as opposed to the ID interests. But there's no evidence about that. The role of the placement agent was referred to in the offering memorandum. And there was, I think, a couple of months before the agreement caught up. So there is simply no material upon which Mr. Justice Knowles or this court, I would respectfully submit, could conclude that there's any even hint of a conclusion that could be drawn from the status of the placement agent and whether it was or was not something of an afterthought. It was also said yesterday, and we haven't got a transcript, so I hope I've got this right, but it was said that FMB did very little. There were no findings about that, and great respect, I don't think those sorts of remarks are very helpful. Whether FMB did a lot or a little, and what it was worth in what lot or little it did, is not a matter that was canvassed before Mr. Justice Knowles. He made no findings on it, and one can't derive, if you're the appellants, some succour from chance remarks of that kind. So the defendants knew the structure.
Can I just ask you about 104? Another question on 104. I mean, the judge says, in the circumstances discussed, I'm able to make finding 8.3. Do I take that just to be a reference to the previous paragraphs? Because he doesn't. Where does he actually discuss the question of whether there was a 2015 profit share agreement?
I think it's in the section I've taken you to, paragraph 90 to paragraph 104.
And there's just a series of recitals of evidence.
Yes.
Okay. Then he goes on. This would still leave FCM London entitled to payment from Fimmel for FCM's work in relation to the fund.
Yes.
This would be so even if in practice that payment went to FAL. What does that mean? I mean, he's recognising, is he, that in practice it was open to the parties interested in FCM London to agree between themselves that what would otherwise be something to which FCM was entitled would actually be paid to FAL Jersey.
I don't think that can be right, Lord, for this reason, because as Justice Knowles' judgment, taken as a whole, makes it very clear that he held that there was a difference between the Table 17 payments and the termination fee payment, and he held clearly that the termination fee payment had to go to the fund because it was the fund's right to receive it. So I don't think that can be taken to undermine.
I think that's, with respect, I'm not sure that's really the point. He's making here that a payment that would go to FCM London from FIML under the investment advisory agreement could, he says in practice, and I assume he means by agreement between the persons interested in FCM London, go offshore to FAL Jersey.
I think all
he's just not dealing. He's just not dealing here with. At the moment, as I understand it, he's not dealing with payments to which the fund would be entitled. He's looking at it further down the chain.
Yes, what he says in this paragraph is that there isn't a profit share agreement involving the fund and FIML, and you've seen how that's been variously put in the amended defence. So I think I'm agreeing with your Lordship, but let me just say what I think your Lordship's saying, and correct me if you think I'm wrong, that would mean that whatever was due to the fund goes to the fund. If the fund then pays FIML, FIML will then have what he calls an entitlement. FCM will then have an entitlement to money. Leaving aside the entitlement question and what that's worth, it might then be open then, subject to all sorts of things we're not concerned with, such as tax and so on and so forth, for that to be paid offshore. Very difficult to see in certain circumstances how that would be so if the money was in fact due to FCM, but that's not something that is before the court.
Well, no, what he's appeared to accept, I think that is rather where we're headed. What he appears to accept is that it's open to, because he says this would be so. You know, he doesn't treat this as something illegitimate. As I read it, he's saying that the parties interested in FCM could, between themselves, in practice, agree that something to which FCM London would otherwise be entitled under the investment advisory agreement would be paid to somebody else, namely FAL Jersey.
Yes, but that would then require. I think that I agree that that's what he's saying. But it would, of course, then require the agreement of the board of FCM London. But leaving that to one side, I also think Mr. Justice Knowles is assuming, for all practical purposes, whatever was going on had integrity attached to it and nothing else. As there was no material for him to think otherwise. But I'm therefore not disagreeing with your Lordship, I hope.
No, I'm
putting it in my own words.
I'm not. I'm trying just to understand what you think. You say he meant by that last sentence.
Well, if I can venture what might have been behind it, but I have to say it's speculative. What might have been behind it is that he wasn't ruling out the possibility that having dispensed with the profit share agreement and saying what needs to go to the fund must go to the fund, he's not thereby to be understood to rule out the possibility that further below that, parties could reach agreement if they wished to. That's all I think he was doing. I don't think it was intended. I don't think I shouldn't say it in that way, but I didn't read it as qualifying or impinging upon the conclusions he had reached in the 2013 and 2015 PSA sections.
Right. Okay.
So let me then. I think I've covered a number of questions. So let me just catch up. Mr. Elias was saying yesterday that the judge had asked the wrong question. So I've highlighted this as a possible issue which might assist and illuminate the appeal and the debate. The question I understood him to ask was, did the individual defendant subjectively believe that the fund would lose out? Well, in a sense, it's a question that he would like to impose to put forward because he thinks he can answer it. in a way helpful to his clients, but it's undoubtedly, we say, not the right question. And one of the themes I'm going to be developing during the afternoon is why it's not the right question. By way of introduction to that theme, it ignores the context of a situation in which the individual defendants feared that they would lose the money if the fund's contractual entitlement was followed, because if the money was paid out, it would go to FINL. That's the context. Now, just to give you an idea of where I'm going to go with this investigation, is that what Mr. Elias is trying to do is to take a 6-month scheme, and that is how long the scheme was afoot, as I will demonstrate. He's taking a 6-month scheme, looking at the last part of it, and saying part of that scheme may not have caused one party loss. And that's not the right way. You can't parse out from the scheme the mechanics by which the scheme was to be implemented. The idea of denying the fund the receipt of the money.
Well, the fund did receive the money.
Well, it didn't reach them.
It did. Fund solicitors had it in their client account.
And they paid it away pursuant to...
Yeah, but you said the fund didn't receive the money.
In the sense that they never saw it, they didn't receive it. So I was using it in a...
It was held for them by their solicitors in their client account.
Yes.
In what sense was that not received by the fund? I mean, the reason it was, I suggest, it was paid, required to be paid into the fund's solicitor's client account, was so that the football club could get a good receipt. That's the standard conveyancing approach.
There's no evidence about that, but I've no doubt that's... I can't think of a different reason.
I mean, the demand letter, it's called a demand letter or whatever, didn't actually say paid into our solicitor's client account, did it?
I'm going to walk you through the cancellation letters and so on and so forth during this
okay,
afternoon.
But in any event, I mean, the money was received by
I take
fund solicitors into their client account.
Well, I take Launcelot's point. It was received momentarily, as it were, and then it went off again, but not in accordance with the fund's direction. So the fund never received the value of that money.
Well, okay, we'll have to get into that. I think that the point put against you is it's received and paid out in accordance with the direction of somebody who was authorised to represent the fund to the solicitors through the contractual framework.
I'm sorry, I didn't quite hear what your lordship
said.
said.
As I understand it, the argument that's put is that, yes, it was received by the fund into their solicitor's client account and then paid out as instructed by Mr. Nuseibeh, who was the person who had been identified as somebody from whom the fund solicitors could receive instructions on behalf of the fund.
Well, at that stage, the question then becomes critical as to whether he was in fact acting on behalf of the fund or on behalf of himself and his colleagues. And the answer to that is, we would say, unquestionably the latter. He was not undertaking the fund's business in having the fund's money paid to someone else. That couldn't conceivably have been a discharge by him, and either later today or first thing tomorrow, I'll be coming along to see how this interacts, we say, with clear, I won't use the word clear, how it interacts with findings in this judgment, that this judge did find there was a fiduciary duty. I will be coming back to that in due course, because Mr. Nuseibeh was a conscious wrongdoer when he issued that instruction. That's what we say. And the critical importance about this is that they started with the proposition that the fund was a party to the profit share agreement, and with the proposition that Bataz had authority from the fund to bind the fund, and the fund knew all about the PSA and the ability of the PSA to extract money. I'm not using that with a capital E, but extract money at any level of revenue coming into what might loosely be called something with the name Floreat attached to it. And that went And the reason I've taken a little bit of time to walk you through what the profit share agreement was said to be and how it was comprehensively failed is because it informs everything that was put forward by the defendants at the trial. Now, that may mean that there are, as it were, it causes an alert looking at the judgment, just as your lordships have said you'll want to have an alert looking at the judgment, given our failure on the misrepresentation claim. And I absolutely take that point. But the point here is that I would agree with your lordship. I'm sorry, that sounds very rude. I didn't mean it to be that way, but I would submit that the proposition that we would say is right is that Mr. Nuseibeh was authorised to ask for the money to be paid to Burgess Salmon. He was not authorised and was out with his scope of his authority to cause that money to be paid to IRL. That's the difference. So I'm going to come on and show you some evidence in due course. But,
or to FCM Claimant?
Or?
Or to FCM Claimant?
Yes, on the judge's findings, absolutely. He has found,
so Mutaz was dishonest as well.
Can I answer that point? I know, I anticipated I was going to be asked something along those lines during the course of today or tomorrow. As Fibble's representative, whether as assignee or not doesn't make any difference. I would express disappointment with the judge's findings, but I must absolutely respect them, and I do. So nothing I'm about to say is attempting to do otherwise. The point that was made yesterday is whether there is, I think that was the point which was occurring to at least one of your lordships, was whether there is a difference in treatment between Mutaz on the one side and the individual defendants on the other. And I'm going to explain why I divine no difference in treatment at all. Because the judge made the two findings he did. That is to say that Mutaz did not have authority and knew it, and in the knowledge that he didn't have authority, he therefore gave what I'm going to call informed consent, that is to say informed by his lack of knowledge. That's what I think the judge meant, to send the money off to the two claimant companies. He also said that Mutaz had a lot to answer for, if you'll remember, or Lordship will remember that paragraph, but he didn't go further. And I would respectfully submit that he didn't go further entirely properly. There was no claim against him, no claim by the defendants against him, no cross-examination of him by the defendants, of course, because it was entirely contrary to their case. And therefore, nothing had been put to him for him to answer in respect of his state of mind or what he thought he was doing and why. So there are lots of other questions put to him, and I think it would be fair to say that Mr. Cavender and I treated as something of a no-holds-barred trial. So Ms. Mutaz was given a robust cross-examination. But the one thing, but I didn't criticise it, the one thing that was never put to him was what I was putting in reverse to the individual defendants. So I would respectfully submit, for what it's worth, that his lordship at trial went no further than he went for that reason. And
it wouldn't be put to him because the defendants were in the same boat as him for this
Correct.
purpose, and it would therefore not be in their interests to put to him that he was dishonest, because that would mean that they were dishonest too. But so I see as it were, the forensic position in which the parties were, but is it not relevant in considering whether the defendants were dishonest to have in mind that no suggestion of dishonesty was put to Mutaz in that regard at any rate, that it wasn't suggested that the solicitors did anything improper or ought to have realised that anything was going wrong, and that when the Mutaz payment was unravelled in 2019, the money was paid out to FIMB just as it looks as if it would have been had that happened in 2017.
Well, my answer, if I may say so, to that is that it doesn't inform the correct judgment about the state of the mind of the individual defendants. And I think Mr. Elias was entirely fair yesterday, if I may say so, in answer to one of your lordship's questions. I'm going to call it the symmetry question because that's a good shorthand. He said, well, of course, I mean, if he'd been asked questions, he may have put forward different answers. I mean, his state of mind might be different if were it to have been investigated. And I think he was therefore, conceding is not the right word, but he was acknowledging that there might be different answers in relation to different people involved in the same transaction.
Did Mutaz accept in his evidence that he was dishonest?
It was never put to him that he was dishonest, and he didn't know. It was never suggested by anyone to him.
Why was it not put on behalf of Fimmel? Well, he gave evidence.
Yet I called him.
On behalf of Fimmel. And
I called him on behalf of Fimmel as assignee.
As assignee of the fund.
Yes.
And it was said that those who procured, and I'll use just a neutral word, procured that monies were paid to IRL were dishonest. But it was put, or your case, that the diversion or the procurement of the funds being paid to FCM Cayman was not dishonest.
The procurement of the money to FCM Cayman wasn't at that stage in issue.
Well, it's because it's the same transaction.
Same transaction, but it wasn't issue. It had been repaid. In addition to which, Mutaz's evidence, though it wasn't accepted, was that he had been misled into agreeing what he'd agreed. So that was the forensic state of the evidence at the trial. He was saying, I understood it was a bonus fee. The bonus fee misrepresentation. Now it turns out when the judge delivers his judgment that he didn't accept that. But that was the way, that was the positions between the parties respectfully. In addition to which, as we will see, Mutaz involvement in this episode did not start until the 19th of June. The individual defendants' involvement in this started in December 2016. So they're not even remotely in the same position or in the same boat. So, Rob, I understand why your lordships are asking me the question, but in a sense, the position we were in at trial was entirely different from the position that we find ourselves in now, for the reasons I've expressed. So, the individual defendants, all three of them, were held by the court, and you've seen the reference in the paragraph of the judgment this morning, were held by the trial judge to have known of the quarterly NAV requirement.
Just give me the reference. Which paragraph?
Give me 2 minutes. I will give you the relevant paragraph. I think it's from recollection 135 and 136. Let's see if my memory is right. I'm getting some appreciative nods from behind. Yes, 135, 136. Page 143. I appreciate entirely that there are other passages in the judgment which merge knowledge with constructive, but here it's very plain. And as you will also see, Mr. Diallo, but only Mr. Diallo, was aware of the cash reserves point, the break fee point. So, as a matter of,
and where is the evidence, or what was the evidence of actual knowledge?
yes, so far as Mr. Diallo was concerned, he was involved, I'm reminded, in drafting the offering memorandum. I cross-examined him on it. In fact, I think I cross-examined all of them on the NAV requirement, for recollection. And the judge was able to form a view pursuant to that cross-examination as to whether they were aware of the terms, 3 of them in relation to the NAV terms and 1 of them in relation to the cash reserves terms.
So so 6.6 and 6.7, those are actual knowledge findings, yes, you say, based upon evidence given at the trial.
Yes. I have, for what it's worth, I can't give evidence, I'm not going to try to, but standing here, I'm not to stand here and say something I don't think is right. If I thought this was wrong and the constructive paragraphs were right, I would say so. I have no doubt that there was material before the judge from which he was entitled to make a judgment, which he plainly has, in the terms of 6.6 and 6.7.
It looks to me as if the judge was entitled to make that finding, I must say, based on what you've shown us, but it only goes to their knowledge of the terms of the contracts. I understood the defendant's case to be that, although these were the terms of the contracts, in practice, that's not how it worked out. And if that is the case, then how it worked out in practice could be said to be relevant to the question of their dishonesty or otherwise. The judge, if I've misunderstood what their case was, then you'll tell me. But the judge doesn't really go on to deal with that. He just looks at the finding you asked him to make and says, yes, I'll make it. But it's specific to knowledge of the terms of the contract.
Specific to the rights of the fund and the obligation of the fund to its investors to hold a quarterly assessment. Now, I would venture to submit that there are no findings in this judgment about it. But let me start it with an if. If it were the case that on occasions money went in and came out before a quarterly investment assessment had been made, that doesn't entitle the individual defendants to take a decision that the fund should be denied the opportunity to comply with its obligations to its own investors, because that is undoubtedly what they were denied on this occasion. I have to leave the cash reserves point aside because it affects 1 of them only, not 3 of them. So I'm concentrating on the NAV for that reason. But Mr. Diallo also knew about the cash reserves. Now, he did give explanations in his evidence that he didn't think that was for the lifetime of the fund, or he thought it meant something else. But the judge was able to take a view about that. I don't think for this purpose, given that he's treated all 3 of them the same, it assists me to draw the difference between the NAV and the cash reserves, and I'm not focusing on the latter.
Can you just, for me, give me the references to the term of the offering memorandum that contains the NAV assessment requirement, which is referred to in 6.7, and then the term of the offering memorandum which is referred to in 6.6?
Let me hope I can do that relatively quickly. Can I let me see if I've got that marked. I think one of the passages you looked at yesterday with Mr. Elias had the reference to, let me see if I've got it, I think I did have it marked. No, Lord, I can't put my hand on it instantly. Oh, well, this will do for the break cost one. Para 72, so that is S1, tab 4, page 72. It says if break costs, prepayment fee or premium over principal or equivalent is or are payable on early repayment or disposal, these costs, break fee or premium, will be added to the fund's cash reserves to meet any shortfalls in income received or principal repaid.
That's the cash reserves one, is it?
That's the cash reserves.
I think we were taken to the one at the bottom of page 69 yesterday.
But it's the same language.
Same language.
I think it's in addition, as Mr. Elias said yesterday, some of these come up repetitively, and I think they're in the same terms.
So
I'll check that overnight. If they're in different terms, I will tell you. But would you make a working assumption they're the same for the moment?
yeah. And although it doesn't obviously refer to Reading, but it's just a break fee on a loan.
Yes, it wasn't Reading specific.
It's generic, right? Okay. No. And then the NAV assessment, you have to come back to us on.
Can I come back to that? I can't instantly see it. Yeah, we'll find it. Thank you. Sorry, Lord, I haven't got that. I think
No, I'm sorry, this is just me forgetting something, but you said before this last exchange you weren't focusing on the cash reserves, because I think you said that point affected only one of them, as opposed to the NAV point, which affected all of them. Could you just remind me why that is?
Paragraph 136 and 137 of the judgment, the two findings the judge made.
Oh, thank you. It's
related to Mr. Diallo. 616 related to Mr. Diallo.
Yeah.
And 616.7 related to all three of them in the NAV.
Thank
so
you
it's
very much.
judgment page 143, paragraph 135.
Yeah, thank you.
Now, Lord, I could say, just a question of abandoning a point, I could say that there is a reference to all three of them having constructive knowledge of the terms of the having knowledge, being aware of the terms of the memorandum and having constructive knowledge of the cash reserves point. But I'd prefer to stick.
Well,
with
not
the
least because I would then ask you what do you mean by constructive
well,
knowledge.
Indeed, I prefer to stick with the stronger knitting. I'm afraid, and just focus on 135, 616, 6.6, and 6.7. So I would be surprised if the outcome of this appeal is going to turn on esoteric discussion about what constructive may mean in different scenarios. But there it is. So let me go back to the point I was just about to develop, which was the idea of denying the fund receipt of the money was the mechanism by which they kept the money away from FIML and what they perceived as Mitaz's ability to dilute them. So if, when we look at the history from December 16 through to June 17, you see that there was, in the context of the case, a perfectly proper justification for Mr. Justice Knowles coming to the conclusion he did about their scheme, if you like. I'm not trying to use that as a pejorative word for this point, but the plan that they brought together, then what I've been saying to your lordships, and I hope that I will vindicate, is that it will not be right to separate off from them the plan, the mechanism by which the plan was to be achieved. Well, let's take that one stage further, because the fund should have had the opportunity to undertake a NAV, let me put in brackets, if it wanted to. So I don't need to fight the point about whether there had been occasions on the past when it hadn't, or whether there were occasions on the past when the individual defendants thought that the fund hadn't. It's all completely irrelevant. The fact is, it had an obligation to the knowledge of the defendants, to its shareholders, to undertake such an assessment, and that's for the protection of the shareholders. I should call them preferential shareholders, the investors, the coupon shareholders. And it wasn't open to the individual defendants, honestly, to deny the fund that opportunity. It wasn't for them to make the fund's decision. Of course, at trial, their case was the fund had agreed to the diversion of the money because Mitaz had authority, and the fund had signed up to the PSA, profit share agreement. So based on the profit share agreement and authority, their case at trial was that they weren't denying the fund anything because the fund had agreed.
I mean, it must follow from that submission that it was also not open to Mutaz to honestly to deny the fund that opportunity.
Well, Lord, I've answered.
Well, you are. Yeah.
I've answered that.
It must follow logically that it was not open honestly to Mutaz to deny the fund that opportunity.
Lord, can I rest on where I am for the moment, which is that I would respectfully submit that in the absence of a cross-examination on him on that specific point, it wouldn't be right to come to that conclusion, and not coming to that conclusion formally does not affect the assessment one makes of the individual defendants, because they have been cross-examined on it. The judge has seen them over many days deal with the question and has formed a view about their state of mind and their state of knowledge. So I'm not trying to avoid your point, but I would personally prefer to leave my submission on it where I've made it.
So here's another way of perhaps putting that point, to say we shouldn't allow ourselves to be influenced in assessing the case against the three individual defendants by speculating, however persuasive it may seem to us, about whether Mr. Mutaz was effectively in the same boat and not infected by the same dishonesty, precisely because it was never pleaded against him and he didn't give evidence on the point and wasn't cross-examined on it.
As is very often the case in my career, the point I'm trying to make is encapsulated from the bench far clearer than I can do it. But your Lordship is absolutely right. That's the point I'm trying to make. But the judge did make two robust findings about him, about his what he knew of his authority, and I have to respect that. But it seems to me that the judge has, if I may respectfully say so in support of Mr. Justice Knowles, I would submit he has judged well what he should or should not say in circumstances where somebody has not been cross-examined on a point for him to assess his answers. So I've made the point that the fund should have had the opportunity to undertake a NAV. The individual defendants knew that on the findings of the court. They chose to disentitle the fund to that opportunity. And it, for this purpose, simply matters not to speculate what might have been a counterfactual if they had been given the opportunity. Now, the judge found that Mutaz Atabi did not have authority to speak for the board of the fund. So that is an extra point in addition to the failure of the profit share agreement, which was said to have been agreed to by the fund, which later didn't exist, so they didn't agree it. But also he found that Mutaz did not have authority to speak for the fund, and judge found, that the defendants knew that.
So, sorry, maybe I missed it. Was it a pleaded allegation of dishonesty against the defendants that they denied the fund the opportunity to do a NAV calculation?
In terms, no, from my recollection. I'll be told if I'm wrong, but the pleaded allegation is that they denied the fund the money, which gave them an opportunity, an obligation to carry out a NAV. It's just narrowing down that point. But the point, the way I put it, the reason I put it as I put it, was in answer to Lord Justice Males's point, that it hadn't always happened. And my answer to that is, that wasn't for them to decide that it shouldn't happen on the next occasion. It was it's not a primary point, it's a responsive point as to why what they did was wrong, and why their references by them to the fact that it may not have caused a loss if the money had gone straight in and straight out is an irrelevant question.
Well, but I'm struggling with this a little bit. As I understand it, the way that it was pleaded, put, and I think possibly found in the judgment, subject to where we're going to go, is that they deprived the fund of the monies. In other words, the idea that the monies just never went to the fund at all. in fact, what we appear to see is that the monies did go to the fund in the sense that they were received by the solicitors and held in their client account. What is now said was dishonest was you deprived the fund of the opportunity to do a NAV calculation before the fund made a payment.
No, Lord, I hadn't. I'm so sorry I interrupted you.
I mean, because your focus at the moment, I was writing it down, the focus was you said it wasn't open to the defendants honestly to deny the fund the opportunity to do a NAV calculation to protect investors. That's the one critical difference between those two ways of putting it is the presence of the solicitors.
Let me try and explain why I've said what I've said in relation to the NAV. I've said that, but in answer to the proposition that it was open to them to have assumed that there wouldn't have been one. And that's an assumption they weren't entitled to make. When I say the fund didn't receive the money, in the sense that it was received in a client account of a solicitor acting for them, that's one thing, but it was never received in their bank account for the board of the fund to take a view about what to do with the termination fee. It was diverted from the solicitor's fund on the instructions of Mr. Nuseibeh. And I'm going to walk you through the history in due course from December through to June to see how that all arose. So I'm sorry, my lord, if it gave you the impression that I was trying to shift ground to a narrow ground of dishonesty. I wasn't doing that. It was in answer to the point as to whether it was open to them, essentially, to say, well, look, we did what we did, but it was on the basis that no loss or harm would be caused. And my point is that wasn't for them to form that view. Plainly.
But, I mean, maybe one can debate whether receipt by the solicitors counts as receipt by the fund for different purposes. But, I mean, even if the money had been received in the fund's bank account, if it hadn't been paid out to IRL and FCM Claimant, it would have been paid out to FIML, according to what we see in 2019, because there was no net asset value calculation carried out then. There was no suggestion we need to keep the money in our cash reserves. It was simply paid out straight away as an excess. And the only reason the judge gave for saying that he was not satisfied that that would also have happened in 2017 was that he didn't have sufficient disclosure of the fund's documents from 2017, but the terms of the assignment entitle FIML to the fund's documents, so it was entirely within your client's control that the material was not provided to the judge. And in the absence of that, why shouldn't the judge draw the inevitable inference that what happened in 2019 would also have happened in 2017?
Well, Lord,
what's wrong with that?
The finances of the fund in 2017 weren't a pleaded issue between the parties. We were never asked for disclosure on that. That wasn't a point that arose when the follow the money disclosure was sought. Disclosure going to 2017 was not sought. I would respectfully say that judge was entirely correct to say what he said, and I've just turned it up. It's paragraphs 350 to 352.
Well, you fought tooth and nail by the look of it to resist that disclosure and to put forward what turned out to be a false case that this was payment of legal fees, and lo and behold, when the documents turn up, it's simply paid out straight away with none of these considerations about cash reserves and net asset value, causing the directors to blink for a moment by the look of it.
But, my lord, that would not mean a finding inevitably that the court should conclude that that's what would have happened in 2017. The one doesn't.
If the court had concluded that that was what would happen in 2017, that would be fatal to your case, wouldn't it?
Lord, I'd still say no, because the denial of the fund, denying the fund of the money for it to make its decision, was still not open to the defendants. They still can't answer the question how they thought it appropriate, in the absence of the profit share agreement and Mutaz having the authority to speak for the fund, how they, as I'm going to call them a servant of the fund, like you know I don't mean a direct servant of the fund, but they're an indirect servant of the fund.
Yes, I understand that.
How they thought it appropriate to divert that money from the account of Burgess Salmon to their own account, or Mutaz Atabi's account for that matter. I'm not using them in order to avoid mentioning him. They can't get round that. That is not their role. They can't.
Just an error, isn't it?
No, it wasn't an error. They did it deliberately.
Oh, really? I thought it was just transferred in error.
Well, that's what's recorded in 2019 by Mr. Whitworth. I've no idea what caused him to put that there. He wasn't asked about it. So far as I could recall, he was not asked about it on the transcript. I'll have to go back and look, but I don't think so.
It's what the directors of the fund resolved.
I can't. But that doesn't affect.
It's a strange way to describe a dishonest diversion.
Well, Lord, that with respect isn't fair. May I say why?
Well, apart from the Mutaz part.
Well, Lord, may I say why? And I didn't mean it to be impolite.
No, go on. I'm being fairly blunt, so
No,
be blunt back, don't know.
No. The reason I would submit is not fair is because the rightly or wrongly as the court found, and I'm stuck with that, there it is, Mutaz was saying he was misled into approving the payment. So far as the FCM Claimant payment was concerned, it was an error. He authorised it on a false premise. Now, as it turned out, in 2021, to my eternal shame, I failed to vindicate that proposition at the trial, or Mr. Atabi did. But so far as the fund was concerned in 2019, why isn't that an entirely satisfactory answer, which permits them to say this was paid out to his account in error, and he's paid it back?
Sorry, I thought the proposition you're putting to us is that nobody could possibly think, brackets honestly, or indeed otherwise, that it was appropriate for these monies to be paid out at all in the absence of an NAV calculation, or because they were required to be retained as reserves. That it's not a question of Mutaz's belief. It's just that you're saying it's obvious to anybody that they can't do this.
Different point. The bonus fee misrepresentation was precisely, he didn't win on it, but it was precisely that he was told that this was money that was not due to the fund. It was a very, very, very seminal difference between the bonus fee payment had he vindicated that representation, and the termination fee, which we know it to be.
Sorry.
Right. So let me unpick it.
Okay.
I'll have another go.
I don't want to take you out of your.
No, don't worry.
You're going to take us through the documents, I know, and we'll come back, I hope, to this written resolution. But the written resolution is written from the perspective of the directors of the fund.
Yes, the point I was making is slightly different.
It has nothing to do with whether Mr. Mutaz believed it was a bonus fee or otherwise. This is the directors of the fund characterising what happened, knowing that it was a break fee payable on early termination to the fund.
Yes, and Mr. Atabi's error would have been to, in his mind, authorise its payment to his account, having been told that it was not money due to the fund.
No, but the directors know that it is money due.
Well, they do, but
and they still characterise it as transferred in error and say that the reimbursed amount is an excess amount and therefore was and is payable to FIML. But no mention of anything else, no mention of it being unauthorised because there has to be an NAV calculation, it has to be retained in cash reserves or anything.
I understand that, but the point you were pressing me on is how could it be described as an error? The answer is, well, it could be described as an error if in relation to the payment to FCM Cayman, not the payment to IRL, in relation to the payment to FCM Cayman, it was authorised by Mr. Atapi on a false basis. He made an error, falsely induced. He was told, this was his case, he was told that the money he was authorising to be, let's use the word with a small d, diverted, was money which was not at all due to the fund. It was additional to the fund's contractual obligation under the loan note. Now that was undoubtedly an error if Mr. Justice Knowles had agreed. But he didn't. But what the timeline that your Lordship's looking at is 2019. So I wouldn't, I'm not going to stand here and concede that that is not a fair representation of what was understood at that time. That is to say, in 2019, before judgment in 2022. I mentioned 2021, but the trial was 21, judgment 22. So, well, I'm sorry, we seem to have got stuck in the weeds on this just a little bit, but it's important, and I think it was important, that I've drawn the distinction between the case we lost, which was the bonus fee misrepresentation, and the termination fee. It's the same cash, but according to our case which failed, it was differently represented to Mr. Atapi. That's the point.
Right. Well, as you say, we've got stuck in the weeds a bit.
I think
we better give you some open water, I think.
Well, let me. To be honest, if I may say so, I would much prefer to be interrupted and deal with these points as I go along. And I will promise to catch up overnight. So however long it takes doesn't worry me at all. So not only. Let me make this point. Not only should the fund have been given the opportunity to decide what to do with its own money, it's not only when if it was paid or how much was paid, but when it was paid. And of course, the scheme that the individual directors had was to transfer the money almost immediately at Burgess Salmon's account. So there's a timing issue. So whether they're paid at all, first issue, how much they're paid, how much is paid out by the fund, second issue, what would trickle down to them or sideways to them offshore, if you like, from FIML, third issue, and when all that happened, fourth issue. And they absolutely sidestepped all that by taking the fund's money when, as the judge found, they knew Mutaz had no authority to agree it, and they knew it was the fund's money. So they weren't coming along saying it was a bonus, not the fund's cash. That wasn't the issue. They concede, they knew at all material times that it was the fund's money. Their purpose was to divert it so that they got not less than 50% of it straight away. And I would respectfully submit that that conduct, being conduct which they had planned because they were not prepared to accept the risk of dilution, as the judge found, his words, could in no way be categorised as honest. And fashioning an answer to that submission by saying, well, we might assume a counterfactual, that it might all have happened anyway, and the fund might not have made a loss. That won't do. It's not an answer to the fundamental dishonesty of somebody who is charged with looking after the money of someone else who diverts it to themselves. So, if if your lordship were to consider paragraph 90 of Mr. Diallo's witness statement, that's, I'll just give you the reference. Go to it, please, if you wish to, but S1, tab 25304. But it's quite clear when you read that, even on Mr. Diallo's evidence, is that Mr. Taber's first reaction was to say, well, the money should go to the fund, on his case. And he said, well, if it can't go to the fund, it should go to Fillmore. That's Mr. Diallo's evidence.
So paragraph 90.
90. So Mutaz's first reaction to this was to say, if the money is due to the fund, send it to the fund, according to Mr. Diallo. Now,
he says there, I see, we agreed the termination fee should be split between FIR and FCM.
yeah, he would
Subject to lawyers' approval. Who are the lawyers he's talking
No idea. Was that Burgess Salmon? Yeah, there was an issue about Burgess Salmon agreeing to pay the
Right.
the sum in two directions.
So it means the fund's lawyers rather than some other advisors. Yeah. Okay.
So I think it was a division of payment issue rather than anything else. Whether it could go in two different directions.
Oh, I see.
From the Burgess Salmon account.
Yep. I see.
So you're going to be dishonest subject to the approval of lawyers?
Well, that, as I understood it, was something
It's a
from...
strange sort of dishonesty, isn't it?
Well, no, because no, with respect, Lord, not. The only thing they're talking about there is whether the lawyers will agree to payments. On his case.
These are the fund's lawyers?
Yeah. But they're going to receive instructions from Mr. Nuseibeh. And Mr. Nuseibeh, as the judge has found, this is the difficulty with this, which is picking out a paragraph from a witness statement, but as the judge has found in this case, having cleared away the profit share, having cleared away authority, and in our case, having cleared away the bonus fee representation, we now know what's left. What the judge has found is that Bataz didn't have authority to agree it, and the individual defendant knew that. Now, when we'll see, we talk about the fund's solicitors. There is no communication to Burgess Salmon instructing them coming from anybody other than one of the individual defendants. I'll show you that in a minute. Purporting to be acting on behalf of the fund.
Well, they could at any time have asked one of the directors. I mean, the fund solicitors could at any...
Well, they could have done, but the fact that they could have done doesn't exculpate somebody who has worked up a scheme to divert the money. So let me take you to that document. It's the A4 file we put in this morning. Go to tab 1 of that if you would, please. So you'll see in the top left-hand corner, strictly private and confidential, with the attention of Zaki Mohammed. Underneath that, Global Fixed Income Fund 1 Limited, so that is the fund. Care of Floreat Group, Hanover Square, London. Thank you for instructing Burgess Salmon. This letter and the accompanying documents set out the scope of our instructions. Drop 2 paragraphs down. The fund has granted its investment advisor, Floreat Capital Markets, permission to give instructions to liaise with us. There's no evidence of that permission. But no one has ever said that were the individual defendants acting on the funds in the fund's best interest and on the fund's behalf and acting properly, no one would have said that they were wrong to have gone and instructed Burgess Salmon. That's not the point I'm making. So there's no point, nothing else I think to look at in that.
What about the paragraph below the address and email.
Yes, we may take instructions from, provide advice to this matter to other individuals within Floreat and the fund, including but not limited directors of Floreat. I'm not sure who that would be. I would read that as Floreat Capital Markets Limited. Sorry?
It's defined above.
Yes. So, yes, I'm great. Thank you. You're quite right. So, Floreat is a defined term. So, the other directors of Floreat Capital Markets Limited and Ben Churchill. So Mr. Nuseibeh wasn't a director, Mr. Churchill wasn't a director, Mr. Diallo was, Mr. Taby was. So Lord, I wouldn't want it to be understood that someone on behalf of the fund had instructed Burgess Salmon to act on the instructions of Mr. Nuseibeh, because that is actually how it happened. I don't know what turns. I don't think anything particularly turns on it. I just don't want your lordships to think it's other than what we see here. So I've made the point that it is not right or fair to, I've used the word parse, if you'll forgive me, but to parse the conduct in a way to isolate what happened in June from what had gone on in the previous 6 months. So, can I loop back then to the question of authority, because this also impacts on the judge's finding? Can we go back, please, to pick up where we were in looking at how they put the profit share agreement case? But in addition to the profit share, they would also have to say that Mr. Taby agreed that the money should be diverted, either with the authority of the fund or speaking as the authority of the fund. We've dealt with that at paragraph 24 of our skeleton. The judge rejected this too, and it is not appealed. So can I invite you to take up the judgment with me for a moment and go through some of the paragraphs. So let's start, please, if we may, with paragraph 129. I think you were taken to this paragraph by Mr. Elias. If you've got this marked already, you have been taken to it. If you haven't, then I've misremembered. So, Mr. Taby's authority for the fund and FIML was not without limit. It didn't allow him to treat assets of the fund as his own, to apply to his advantage or give away for his own purposes. That limit did not prevent his giving instructions that authorised compromise or concession when that was in the interests of the fund. Lord, just to explain that, that was in relation, obviously, to the missing termination fee and so on and so forth. That was the judge saying we were wrong to criticise the individual directors in that regard, and Mr. Taby had...
We were taken to this, and in fact it was Mr. Elias's submission that what the judge describes here mischaracterises what actually happened. He says it wasn't a case of Mr. Mutaz Taby giving away the money for his own purposes, but
well, he does.
Giving effect to the contractual structure.
Well, we've moved from profit share to contractual shortcut, and I'm going to come and say one or two things about contractual shortcut in a minute.
Yes.
In a nutshell, it won't do, and it doesn't get them out of trouble. If I'm right about that, there's going to be a very short submission. What I will be coming back to say, and I've got it in my note, but let me pick up your lordship's point at this stage, and then forgive me if I repeat it when I come upon it later. I do appreciate what Mr. Elias says about 129 and the subsequent finding of it in the dishonesty section, which is almost in the same wording. I think 372. I do understand what he says, but what comfort he derives from that is the judge has misled himself that was the situation he was dealing with in this case. But he can't conceivably have misled himself to think that that was the situation he was dealing with in this case, because he knew precisely what he was dealing with in this case. He was dealing with a diversion to the individual defendants and Mr. Taby. So it's a point without any substance at all. And I'll come on to vindicate that when we get on to 372 in due course. It's quite right that the words say what they say. But it's quite wrong to submit that that means that the judge addressed himself only to that wide question without reference to the facts of this case. That would be simply absurd, because this comes on page 142 of his judgment. There's about another 350 pages before we get to 372, where he repeats it. And the whole judgment...
Well, in fairness, it's only page 25, actually, of the judgment.
Oh, you're quite right. I'm sorry. 142 of the bundle.
It may feel like page 142.
Well, you're quite right. You're quite right. But anyway, look, it did get up to 200 pages eventually, so I think the proportions were almost there. The situation is that it is, with respect, not sensibly open to submission that he's asked himself that question when addressing the facts of this case, because we have 500 paragraphs addressing the facts of this case. It's just how he's chosen to write it down.
Do we know where this language derives from? And it may just be the judge thought it up for himself as just a perhaps rather graphic way of expressing a concept about what Mutaz could do with the funds if he had complete, as it were, sovereignty over them. Or indeed, but since so much of this judgment is made up of either accepting or making variants on findings that have been suggested to him, I just wonder whether...
I don't think we're responsible for that one.
It's not obvious from the immediate context that this is a part of or relates to a finding that was requested.
I don't believe that we used that formulation in the finding we invited him to make. Just on the findings, by the way, this was such a hard-fought trial with a very large number of issues. And the team, and I take full responsibility for it, that the team decided it would be helpful to try and put somewhere near the front of the closing skeleton a list of things that one then hoped wouldn't get lost in the wash, and they would be addressed. And for the most part, they have been. So that was how it arose. It wasn't a request from the judge. He didn't ask us to do it. We didn't tell him he had to do it, but he obviously found it helpful. So, whether I would do it again, I wouldn't be prepared to comment at this stage. But I'd say no more than that.
Anyway, he usually quotes you when it's your language, and he doesn't hear. So perhaps
it's normally, yeah. I don't think that's us, but I wouldn't be definitive. But I don't think so. But I would respectfully agree that sorry, agree. Your lordships haven't made a finding on anything, but I would respectfully submit that the submission made by Mr. Elias on this point is a poor one, because it's suggesting that the judge has asked himself the wrong question. But when there's 500 paragraphs of analysis of the facts relating essentially to 4 human beings and 1 or 2 others, he cannot have asked himself the wrong question. What he was addressing was what happened on this occasion. In other words, the diversion of the sum to the individual defendants and FCM Claimant. That's what he was addressing, nothing else. I would respectfully submit.
I mean, I know you say this is not what happened, and maybe it's not even what was alleged to happen, but I suppose Mr. Mutaz Taby would be authorised to negotiate the fee payable to FCM. That would be, I suppose, a negotiation on behalf of FIML.
Yes, he was. The judge made it very clear that he was authorised under the FIML IMA to have given instructions to the individual defendants, the effect of which was that they could do a compromise deal and come back with a decent fee, less than the full amount. That's why we lost on the missing termination fee. And he also, well, he's used the word, as we've seen in this paragraph earlier, he's used the word of entitlement between FIML and FCM. But leaving that to one side, Mr. Itaby undoubtedly had authority on behalf of FIML. That absolutely can't be gainsaid. the issue in this case, and it's all gone away because the profit share failed and the authority failed. The issue in this case is whether, when he agreed the profit share, brackets, which didn't exist, close brackets, he did so on behalf of the fund, and when he told them to do what he told them to do, or authorised them to do in relation to the diverted sum, he did so with the standing authority of the fund. And the judges said no to both of those. Well, that's one of the reasons it's so important to understand what forensically was at the trial, what we were all talking about. Now, I appreciate that may leave your lordships alert to the way the judgment tackles then what was left, as it were, the very important residue. But it's just as the learned friend can say, well, there was a switch in the case sometime between the summer of 2021 and the judgment coming out in 22, where we'd lost the bonus fee. But there is the equal and opposite difficulty for the other side, that they put their case on an entirely different basis at the trial. Very different from what they're putting here, if you analyse it. So can we now look, please, at paragraph 333. I'm going to invite you to look, I'll just invite you to read them to yourselves, actually, if I may, because I can be quicker. 333, followed by 338. Your lordships have finished that. Can we go over the page, please, to 183 in our bundle and paragraph 342? So that's one of the two key paragraphs in relation to Mr. Taby. We could then, not going too fast, forgive me, 372. That's the second paragraph, which reflects the wording that we've seen in paragraph 129. Now, all that shows that there was no authority and that the individual defendants knew that. There's no appeal against the findings that Mataz did not have any authority. So what we find when we come to this court is that the appellants, the individual defendants, have devised what they call the contractual shortcut. And the way it's put in Mr. Elias's skeleton, paragraph 7, is that on the 19th of June, Mr. Taby, the third defendant, and the individual defendants agreed that the termination fee would not be paid to the fund as it contractually should have been, but by way of shortcut should be treated as if paid to Fimmel and then onwards to companies representing the Floreat Group's interests, FCM Cayman, and the independent's interests, the fourth defendant, IOR Relations.
Sorry, which paragraph are you reading from?
Lord, I'm so sorry. Paragraph 7.
7.
Is the note I've made, unless I've given myself a poor reference.
No, you may well have done. Yes, that's it.
Thank you. So we get this, as it were, contractual shortcut. So it's accepted in this skeleton that it should have been paid to the fund. The position was subtly different at trial, which was that while that was the starting point, Vataz had authority to divert it from the fund. And therefore, when he instructed them, he authorised them to do so. That's gone. That failed. So this is a new case. This is not it being sent off with the approval of the fund. The contractual shortcut is designed to, if I may be forgiven for saying so, reposition the individual defendant's case in the light of their failures on profit share and authority. Now, we have provided an analysis in paragraphs 20 to 24 of our skeleton of why this does not work. May I commend that text to you? I know judges hate being left what one might call out of court homework, but may I leave that with you because you will have read it already. But paragraphs 20 to 24. But in addition to that, let me just enumerate in my own language on my feet why this does not work. It fails on the authority point, as we've just seen. The contractual shortcut is no answer to a lack of authority because there was no authority to divert the money away from the fund solicitor's account. If I put it more accurately in answer to Lord Justice Snowden's analysis of the solicitor's intervention, I don't wish to go back on that. There was, it's said to be a contractual shortcut, but there was no contractual link, and we can pick that up in the judgment 363 to 369.
Are you going back to 333? I mean, the 333, 338, 342, 372 are the core thread.
They are.
The judges, are you going to go back and look?
I am going to go back to look at the specific paragraphs under the heading of dishonesty.
Okay.
Because, Lord, you're going to want an answer from me as to where I say he's considered subjective dishonesty and where he's considered objective dishonesty. I'm going to come back to that, but I hope persuade you that he has done that. I promise. So 363 to 369 makes it clear that there was no contractual link linking what's now said to be the contractual shortcut, because it doesn't involve the fund. They can't get round that. They cannot get round the proposition that this money should have gone to a fund's bank account unless the fund authorised otherwise. The next point is we know that the individual defendants did not want the termination fee to be paid to FIML. Had the money been paid to the fund or FIML, the defendants were worried that they would be diluted. And that is clear. Lord, I don't think I don't propose to trouble you tomorrow with whether you should or shouldn't look at the extra bundle. I think it's just the outcome of this appeal is not going to turn on that. I can't imagine that it would. But page 40 of that has got. I've got my page. I may have given myself an incorrect reference, do forgive me. Can I come back to that? But there's some cross-examination in that file, which I just want your lordships to note. And I'll come back to it when I probably first thing in the morning and just give you the correct reference. I'm not sure I've got the right one. But what is clear, and let's be absolutely clear about what the scheme was. The scheme was to ensure that the money never went to the fund, because if it went to the fund, it would go to FIML. If it went anywhere and went, leaving aside the timing points and the NAV points, leaving all that to one side, it was to stop it going to FIML. That was the purpose.
Those are two different things. I think what's said is they definitely didn't want it to go to FIML, and it didn't, because if it had gone to FIML, it might have been diluted. they didn't see preventing it as going to the fund as being the mechanism by which it would be stopped from going to FIML. As far as they were concerned, I keep on coming back to it, it was paid to the fund's solicitors.
No, Lord Mayor, may I very respectfully disagree. I don't think that it's ever been the individual defendant's case that they believed that the receipt of the funds by Burgess Salmon constituted receipt by the fund of the money.
But what the scheme, as you identified, I thought you were identifying what the purpose of the scheme was from the defendant's point of view. And I thought that their case was that they didn't want the money to go to FIML, because once in FIML's hands, that meant that Mr. Mutaz would dilute it or might dilute it. So their purpose was to stop the money going to FIML.
Yes, but if it would precisely. But it would go to FIML if it went anywhere. If it went to the fund, because the fund was if the fund paid it out at all, the fund was if it paid it out at all, the fund was obliged to pay it to FIML. So the only way they could bypass FIML and get 100% of the cash was to bypass the entire system and have it paid to IRL before, I will say, before it reached the fund's account, leaving aside the point about the client account of the solicitors, but it went into the solicitor's client account and straight out again. It never went into the fund's own account. And the question is whether that was or was not an honest endeavour, given that the only way they could stop assuming everything against me for the moment, that if it had gone to the fund, it would have come straight out again. There might not have been a delay, there might not have been a NAV, all that, leaving all that to one side. The only way they could stop it going to FIML was to ensure it did not go to the fund. That's the basic problem that they have got, which despite the judge's sympathy for them, because he held that Mutaz had some things to answer for, despite him believing what they were saying in respect of other parts of their evidence, and they've been cross-examined pretty firmly on some of those parts, judge thought they held up. On this aspect, they did not hold up in front of this judge. Why? Because the starting point of it is so unattractive. And he heard them, he assessed them over a fortnight, and he formed a view. And he formed a view about whether that endeavour by them, I'll use the word endeavour rather than scheme. Scheme's got a connotation, and I don't want to try and laugh the language. Whether that endeavour was honestly undertaken. And he concluded it was not. And let me go back. I've been given the reference. Let me go. I was correct. I just couldn't see it when I turned it up. Could we go back, please, to U40? So the new bundle 40.
So is that the unagreed document bundle or your new bundle of today?
The unagreed. And this is a 4-page per page format in the usual way. So I'd like to pick up internal page 74, starting at line 18.
It is Mr. Diallo, is it?
Yes. Mr. Nuseibeh.
Oh, sorry.
Yes. So if you could just read about line 10 on the next page. I can then, I'm sorry, I'm going too quickly, forgive me.
Yes. And what's the point you want to draw from this?
It's essentially the expression that it will be eaten. It's making certain that your lordships understand what the concern was and what they propose to do about it. There's a reference which the judge picked up in his judgment, and I'm going now to, if we may, judgment paragraph 362. And there are various expressions, but this is where the 50-50 but 25/75 expression comes from. that is part of the cross-examination of Mr. Nuseibeh. So it's just the first answer, first 4 lines at the top of page 188 that I want to bring to your attention. There is the possibility we end up dividing it, not the right 50-50, but 25/75. And that FMB was entitled to money cannot be gainsaid, given the structure of the documents which your lordships were taken through yesterday. So it's a very important point is this, because if you start with the proposition that there was a profit share agreement, then the interposition of the placement agent taking off some of that money from FIML before it comes down from FIML to FCM would be seen as a thorough nuisance, a dilution, a breach of the profit share agreement. If you remove the profit share agreement, as the judge has, then you're left with the proposition that there is nothing at all wrong, actually, with money being paid by FIML to its placement agent. And it's no part of this trial, it was no part of this trial for the judge to be asked to make findings about whether the money that had been paid to FMB had been paid for legitimate services or not. As I say, there's no evidence from which this court could conclude that FMB did little and wasn't entitled to much. So let's see what's said about it in the witness statements of the defendants. Could we take up, please, supplemental bundle 62? I'm hoping that's going to be in tab 1, but I might be wrong. I think we've all got slightly, yes, it is tab 1, we've all got slightly eccentric tab numbers. We go to, this is Mr. Churchill's witness statement, so we need page 262, which is tab 24. Could you go with me, please? That should give us page, paragraph 24.
Sorry, could you say the page number again?
Of course, Lord, I'm so sorry. 262.
Oh, 262, right. Wrote it down wrongly. Thank you.
So, in the first line, we pick up this. Within the fund, investors were entitled to a 5% preference dividend, and all profit above that was paid out to management fees, first to FIML, and then to FCM and FMB. So, no apparent quibble there that was the contractual structure established by the documents. But their concern was to ensure that FMB didn't get any money. Could we now then go to, I'm afraid this will be the next bundle, so supplementary 2, please. Can we go to page 313? Tab 26, page 313, where we should pick up paragraph 25. And this has got a passage in here, again starting in the first line. The commercial arrangement is that the fund would pay a non-guaranteed preference dividend of 5% to investors, and all returns above this level would be paid to the investment manager. And on to the investment advisor FCM, FMB would also earn a fee for distribution. So again, same story. Nothing at all inappropriate about FIML paying FMB. That is why the individual defendants, I submit, went on to find an idea. So can we go back to the first bundle?
So I'm not sure. Is the point you're trying to say that they understood and had no quibble with FMB being paid a fee?
Well, they understood that FMB was entitled to a fee.
Right, but their concern was that their profit share was being diluted by payments to FMB.
Well,
I mean, that was the cross-examination you showed us.
but that's their case on the profit share agreement. But there isn't a profit share agreement. So they were concerned about dilution. The judge found as a fact that they were concerned about dilution. The judge found that they were not prepared to take the risk. That's the judge's finding, not prepared to take the risk of dilution in respect of their alleged half of the termination fee. The only point I'm making is that that doesn't appear, if I may say so, to be an honest enterprise by them in circumstances where they appear to acknowledge in these witness statements that in fact FMB was entitled to be paid. Now, there might be an argument about how much, but there was no question that the structure of fund to FIML down to FCM and FMB was the commercial structure that they understood existed. And we know that to be the case because we were introduced to the documentary evidence yesterday.
Okay. I mean, paragraph 27 sets out what I understood their concerns to be. Paragraph 27 on that same page.
Forgive me. I'm sorry. I didn't quite.
I'm sorry.
No, it's entirely my fault.
Sorry, you took us to 25. The reference to
I did.
FMB also earning a fee for distribution. And I was just saying that paragraph 27 set out the evidence as to the concern.
Yes, on the basis that they thought they were entitled to a straight 50%. But they weren't.
Does the submission you just made come to something like this, that if dilution is effectively baked into the structure, and there is no profit share agreement, as the judge found, then you say it is dishonest to take steps to prevent trickle down with a view to avoiding what would have been perfectly legitimate dilution.
Correct.
I mean, is that where you're going?
Yeah. Lord, I'm sorry. I was making that sound very informal. Yes. Yes.
That could only be dishonest if it involved a lack of consent on the part of Mutaz, who is the person entitled to FIML and FMB. If he agrees that the money shouldn't go, to put it another way, if Mutaz agreed the money shouldn't go to FIML, why is it dishonest?
No, I'm tackling it from a slightly different standpoint. In order to prevent the risk of it going to FIML, they devised a plan to ensure that it would not, by bypassing the fund. Now, that plan, I would respectfully submit, was not an honest enterprise for the reasons that I'm in the middle
Vis-à-vis the fund.
developing.
Vis-à-vis the fund.
Vis-à-vis the fund.
But
it would also not be an honest enterprise vis-à-vis FMB, for example.
well, why would it not be honest if the person who owns FMB, Mutaz, agreed it? Why would it be dishonest if he's agreed it vis-a-vis FMB?
If he was the sole decision maker of FMB at the time, I can't recall.
But he, on behalf of FIML, has effectively given up the right to dilute the trickle down. Sorry, there's a lot of jargon in that.
Yes. Right. I followed. Well, I understand that, but this all, one has to understand that this all happened on the 19th of June. That's the first time Mutaz was told about it, asked about it, on the face of it approved it, having first suggested it should go to the fund and then to FIML, then he approved it. But it was still the denial of the payment to the fund. The defendants can't get round that. That was the improper mechanism by which they sought to profit. It then doesn't matter whether Mutaz agreed that they could do it, because he didn't have the fund's authority. But their case at trial was that he did have the fund's authority. They failed in that. So the whole point here is why I'm resisting the siren call from Mr. Elias that what you can actually do is to differentiate in this case between the relationship of those who were properly described as, if you like, with a small s, servants of the fund, and treat that entirely differently from those who were agreeing on the face of it a diversion with Mr. Atabi, as the judge found.
Surely it would only be dishonest if they knew that Mr. Mutaz didn't have the authority.
Yes, and the judge found that they didn't. That's the judge precisely what the judge found. The judge found that they knew he did not have authority from the fund to authorise that diversion, and therefore the difficulty that the appellants have got is they have to unseat that finding.
Well, you were going to go back through what the judge found, those paragraphs that we said, of which 372 is the key in that respect, I think, because that's what what you rely upon for that finding.
I rely upon the judgment as a whole in order to. We haven't got through it entirely yet. I will ensure I catch up tomorrow. I'll have to do some surgery tonight, I think, to cut some of it down, but I will promise to catch up. But the point about this is that the judge has made key findings: no profit share agreement, no authority, let me go back to the first question, no profit share agreement with the alleged JV partners. As a subset of that, no profit share agreement with the fund, because it had never been agreed by Mutaz Atabi on behalf of the fund. Third proposition, Mutaz Atabi did not have authority to divert the fund's money, and they knew it. And the scheme, or the endeavour, was to plan to divert money from the fund in order to ensure that there was no risk of dilution. It therefore doesn't matter what the fund's counterfactual may have been, and does not matter whether Mutaz Atabi agreed that they could divert the money. It matters even less that he took half of it. Because their endeavour, with the greatest respect to them, was not an honest endeavour. It was to cut out the fund. We'll see how they set about engineering that. It was to cut out the fund for that purpose.
Right. Is that a convenient moment?
Speaking for myself, it would be, because what I'd like to do is I'd like to, as is always the case, I've taken some points out of order as they arose in discussion with your lordships. So I know 10 minutes, or an extra 10 minutes to regroup would actually be quite helpful for me, because I think will be shorter in the long run.
Very good. All right. Well, I think
Thank you.
I'm not sure whether we said we'd sit at 10 or 10:30 tomorrow, but it'll be 10:30 because I think the crowds have thinned out.
It's been a bit thinner today.
Didn't have any difficulty, so we'll just sit the normal hours.
Thank you. Now, we were told, ironically, that the moment we left the other court, the noise stopped, or more or less. But are we staying here?
It must be one of you not causing it then. Except no, because you're not doing it here. I think we're here, aren't we?
Yeah,
Yes.
we're still here.
Yes.
Okay. Thank you. That's very helpful.
Very good.
Thank you very much.
Otherwise,